Okay, so welcome everyone. We're going to start this webinar that is on, excuse me, a few seconds, on access to abortion as a human right. So just before we start, a few technical words. Basically, this webinar is going to be recorded, and we're asking you to please keep your microphone switched off during the webinar. And as well, we're very pleased to offer it in English, French, and Spanish. So if you wish to access it in another language, I invite you to please click on the little symbol that is at the bottom of your screen and choose a language that you prefer. And if you have any difficulties, feel free to ask them in the chat. We have many people willing to help you. And just as well, since it is a subject on which opinion may differ, I invite you to please remain constructive and respectful in your comments. So without further ado, excuse me, I will hand it over to Luis Miguel Vasquez, which is a cooperation officer at the Canadian Embassy in El Salvador. So very pleased to have you with us today.
Okay, thank you. Thank you very much. Well, first of all, I want to thank you and I want to welcome all of you to this webinar from our small but sunny and warm El Salvador. I'm here. So first of all, I have to thank Avocat Frontier for this opportunity and for creating spaces like this that are so important and so necessary. For the Government of Canada, human rights are one of our top priorities, especially sexual and reproductive health rights and abortion services. We support their strengthening all over the world with our development projects, especially in countries where the situation is harder than in others, like El Salvador. Even though in my country, here in El Salvador, this is one of the most restrictive countries on abortion laws, we have a Beatriz case that could be groundbreaking for all the women in this country. So I do thank Avocat Sans Frontières for this space, this opportunity, and for all the work they are doing in this case. That is why, like I'm saying, I'm so pleased to be working with you, because you do understand the necessity and the importance of this, even in difficult contexts like El Salvador. But projects like the one we are funding, the project Unidas here in El Salvador, will help to build a better future and hopefully to a significant change for girls, adolescents, and women. I thank once again Avocat Sans Frontières for this webinar and for all of you to be attending this space. And I do hope that we get a meaningful discussion and we can learn from each other. I thank you very much. Merci beaucoup. Muchísimas gracias a todos. And well, I leave you in the hands of Avocat Sans Frontières and Karine Ruel. Thank you.
Thank you so much. Up to me now. First off, I don't really often work in English, so bear with me a little. But so I'm Karine Ruel. I'm the Director for Legal Affairs for Lawyers Without Borders Canada here in the headquarters in Canada. And this webinar is very important because it reaches upon a subject that is very important for the organization, which is access to access to health and specifically access to safe abortion. So let me introduce a few words about that. As you probably know, throughout the last decades, international human rights law has strengthened the right to access to healthcare services in general, including abortion services. International and regional bodies have in fact recognized that women and people with the capacity to be pregnant have the right to access safe abortion services, and that denying them those type of rights could constitute a violation of their human rights, including their rights for private life and their rights to health. At the national level in Canada, you know, after Morgentaler, of course, the case of Chantale Daigle was a key turning point in the country, especially for the development of a jurisprudence in favor of reproductive and sexual rights for Canadians. It was a groundbreaking decision, and that decision, the Supreme Court of Canada held that under the Quebec Charter and the Civil Code, a fetus was not considered a human being and therefore had no legal right to life. Now we are 30 years after, in last month, the case was brought before the Inter-American Court of Human Rights. This is the case of Beatriz. Beatriz was a young Salvadorian woman who was denied abortion services, despite the fact that there was a clear medical advice that her pregnancy was life-threatening for her and that the fetus was unviable in that case. Beatriz, she could not receive the healthcare services that she needed because, as my predecessor just stated, the state of El Salvador is one of the most restrictive countries in the world when it comes to abortion services. It's illegal in Salvador and it's criminalized to access such services, including when the life of the pregnant person is in danger, or even in the cases of fetal malformation. And the mere fact of getting an abortion in that country can lead up to 50 years in jail. So in doing so, the Salvador is failing to respect its international and regional obligations when it comes to protect and to promote human rights, as we will probably talk about a little bit later. While this decision could be groundbreaking for the region, it is very little that has been said about that case in Canada, especially in the media in the country. So this webinar is just intending to provide a small contribution in an effort to recognize the important work that has been conducted by civil society organizations in the region, human rights defenders, legal professionals, and academics working together in the region and beyond to try to bring justice to Beatriz and her family, and to all women and people with the capacity to become pregnant who have been refused access to a safe abortion or have had to face some type of discrimination in the healthcare system, which is also very often. This is also an occasion for us to better understand, why it's really important and why it's at stake in the present moment. I want to take a special moment to highlight the work of our team of Lawyers Without Borders Canada in El Salvador, who has collaborated on this case together with the legal team in Canada. Our colleagues at the country office have collaborated with a partner, the Agrupación Ciudadana por la Despenalización del Aborto, to improve access to women's sexual and reproductive rights. Lawyers Without Borders Canada also provides support to other women's rights organizations to fight against all forms of gender-based violence and to improve access to justice in those type of cases. Their work is an example of the broad type of work that Lawyers Without Borders Canada is trying to support worldwide, which is trying to contribute to the protection and promotion of sexual and reproductive rights in the region, but also in other countries. Another example I want to share with you is we worked also in the inconstitutionality action filed before the Appeal Court of Honduras against the absolute criminalization of abortion, after, unfortunately, the constitutional reform of Congress in the country become more regressive. Also, I can mention the work we do in Guatemala, which is to guarantee access to safe and therapeutic abortion, which is legal in the country, to all. Not to mention, other projects that we also focus on the same strengthening the work of civil society organizations to protect sexual and reproductive rights for women, girls in Mali, in Benin, Burkina Faso, Haiti, or Congo. So today I will leave you with two experts, more than me, to discuss this important case and the impact of the case potentially. And we have the honor to be accompanied by Professor Rebecca Cook, who is a professor emerita at the University of Toronto. And the discussion will be conducted by my colleague, Julia Tétrault-Provencher, who works with us as a legal advisor on sexual and reproductive health in the headquarters in Canada. So roughly the format of it will be a 40 minutes discussion, and it will be followed by a session of, we hope, 15 minutes of questions and answers, hopefully, so we can have a nice discussion. So please feel free to ask your questions in the chat, and we will try to gather them up and answer them at the end of the discussion. So I leave it to you, Julia, and I wish everybody a very nice webinar.
Thank you very much, Karine, and well, thank you for the introduction. Thank you, everybody, for being there. We're very pleased to organize this webinar. So I think I'll just start with some broad statistics, I would say, that I found on the Center for Reproductive Rights website, saying that 5.1 million of unsafe abortions are performed each year worldwide. And also 41% of women of reproductive age still lives in countries with restrictive abortion laws. I say that because, well, the case of Beatriz is one case out of millions of cases that happen every day, every year around the world. So I'd like to know, Professor Cook, my first question to you, and I'm so pleased that you're here today also. For me, I must say it's like I'm meeting a rock star because I mean, I've been reading your articles, your books, and I think, and I thank you also for all the work you've been doing for reproductive justice. And I'd like to know, in your views as an expert, why do you think that the case of Beatriz is so important for the progress of the human rights of women and of people who can become pregnant in the region and worldwide? So why did we talk about it? We'll unmute you.
Thank you, Julia. And thank you to Lawyers Without Borders for hosting this very important meeting concerning the Beatriz case. It is a very important case. It's the first case before the Inter-American Court dealing with women's rights to abortion. Beatriz, as has been explained, was denied access to abortion, even though she was at risk, very high risk of death, and even though she had a unviable pregnancy. She was required to wait from February 18, when she was first diagnosed with a high-risk pregnancy, and then March 14th with the unviable pregnancy, with a pregnancy with a fatal fetal anomaly, until June 3rd. Almost 5 months. This woman suffered with a pregnancy that was unviable and knowing that it could cause her death. So 5 months forced to carry a pregnancy to term, knowing that it was unviable and threatening her health and life. It's not only the denial of access to abortion in this case that's troubling, it's also the treatment of Beatriz. So unethical treatment. The case implicates her rights to be treated with respect as a patient. There was a clear lack of respect for treating the well-being of the patient, a clear lack of respect for the ethical principle of first respect the well-being of the patient. So not only a denial of her human rights, but also a denial of the medical ethical principles of the requirement to first respect the well-being of the patient. And I suspect every ethical medical code in the provinces of Canada have that as their first principle. Discriminatory treatment. Beatriz was a young woman with one child with a underlying health status, lupus, which one could characterize as a disability. So there was intersectional discrimination on grounds of her sex, her pregnant status, her health status, or characterized as her disability, and her socioeconomic status. She was subjected to inordinate delay in responding to her request for effective remedies. So the treatment in and of itself implicates many of her rights. But underlying all of this was the criminal law. No express exemptions, very vague defenses under general criminal law provisions, causing tremendous uncertainty in the healthcare system. She had no rights of appeal within the healthcare system to have an answer within a specified time. There was no protocol for dealing with high-risk pregnancies. So the Inter-American Court has a lot to address in its decision. There have been many, many amicus briefs that have been submitted in this case, and everybody is watching the court.
Yeah, no, yeah, definitely. And I think you just highlighted all the many issues that the court will be has been asked to cover also in the decision. And I think that's a good segue to talking a bit about like everything that surrounded the case, because as we know in strategic litigation or when we use emblematic cases, in this case, we have also all the work of advocacy surrounding it. And I think we cannot not mention the work of the Agrupación Ciudadana por la Despenalización del Aborto and the other civil society organization in El Salvador, who really regrouped and got together to to spark this feeling of solidarity in the region, but internationally speaking as well. And this is a proof here as we are doing this webinar in Canada or here in Quebec for me. And I think this has also shown that the work of the Agrupación, so what they did before the 22-23 of March, so before the case was held before the court. So they had meetings with different civil society organizations. They also organized those media campaign. They organized informative events around sexual and reproductive rights in general. And also what they did, so they called for this, a call for action, I would say, to organizations or academics or anyone, experts actually, would like to write an amicus curiae to a brief to the court. For those who are less comfortable with this Latin word, so amicus curiae is the front of the court. So it's kind of a brief that you can write as an expert to give some information to the judges on some issues, so the legal state of an issue, I would say. So I know you wrote one, Lawyers Without Borders wrote one as well. And this is a bit also what we wanted to talk today, to share those amicus curiae, what they have to say. I'll start with ours because I think yours, as we say, kind of also shed light on a more specific issue. So Lawyers Without Borders Canada, on top of all the work of our team in El Salvador that was doing with the civil society organization in that case, we also decided to write an amicus curiae. And I think it's also a good example here of the solidarity between all our colleagues and international, because we had all our colleagues and international experts working on this. We had some people in Colombia, Honduras, Guatemala, El Salvador as well, and in Canada. So all legal experts reuniting to write this amicus. For me, it's a good also sign of sorority, I would say, and the importance of having important allies as well surrounding us. So we write it on the fact that something that I think you will be not surprised, the absolute prohibition of abortion and its criminalization may subject women and people who can become pregnant to gender-based violence and mental and physical suffering that may amount to torture or other cruel, inhuman, and degrading treatment. Of course, well, in this case, the state of El Salvador has international obligation not to submit people to torture. And we argue that by having those laws that criminalize abortion under all circumstances, meaning even in cases of sexual violence, if the life or the health of the woman or the person is threatened, or in case of non-viability of the fetus. So when you criminalize abortion under all circumstances, then it can lead to acts of torture. Why we say that, I will not go into all the brief, but we did share our recommendations on our website, so you can have a look if you want. But broadly speaking, what we said is that, well, the total prohibition of abortion and its criminalization, it results in intimidation, in humiliation, in punishment, or control of the person who wishes to interrupt their pregnancy. And also it sends a clear message to all women and people who can become pregnant that their right to life, their right to health, their right to physical integrity is not respected and will be disregarded. So we argue that in this case, well, there is a clear criteria of the intent and the purpose that you need to have when talking about torture is met. Because, well, this is clearly discriminatory act, and you will talk more about, I know, the inherent structural discrimination that we have in the healthcare system in general. But that's what we argue. And what we also say is that, well, the violation of which Beatriz was victim is the result of structural discrimination based on multiple factors, including her gender. And I think it's also important, you mentioned also the fact that she was, she has an autoimmune disease, and that she was coming from a rural area in El Salvador. So all those factors building up to a discriminatory act of denying her abortion services, even though it was necessary for her health. So I would say I will not go further than that. I can only say that we have those recommendations. We shared lots of recommendations to the court to ask the state of El Salvador to align with its standard obligations, with its international obligation. But most importantly, we asked the court to ask the state of El Salvador to repeal all discriminatory laws and policies, including in the criminal code, for sure, but also in the code of medical ethics and deontology, because I think sometimes we forget those, but they do have a lot of barriers sometimes, and they represent sometimes obstacles when we talk about sexual and reproductive rights. And also we ask to adopt protocols and guidelines for healthcare professionals to make sure they will practice safe abortions. And interestingly enough, it should be noted that the court already asked the state of El Salvador to do that, to have some protocol in the case Manuela, and which actually Lawyers Without Borders Canada also worked on, our colleagues also worked on, and they asked the state to establish clear protocol for the care of women who require obstetric emergencies. So this is what we wrote in the amicus. It's a very interesting amicus curiae, but I will go back to the fact that we mentioned, so it really builds on the fact that Beatriz suffered discrimination, and also, well, the fact that abortion is criminalized in El Salvador. But I'd like to hear about your brief and what you wrote.
Thank you, Julia. I just want to underscore your point about the importance of medical guidelines and medical ethical guidelines. In many ways, I think the movement has a real opportunity to use these much more to the benefit of women. These guidelines, medical ethical guidelines, were written years ago without really carefully considering the needs of women. So I think there's a lot of work to be done for advocates to really update those guidelines, feminize those guidelines in ways that are much more responsive to women's issues. So that among many things about your brief, I really like that aspect of it. So in the brief that I was asked to do, really my purpose was to remind the court of its pioneering jurisprudence on stereotyping and prejudice. So they started way back in with the Cottonfields case in 2009, where they recognized stereotyping. They took judicial recognition of stereotyping. Then the Atala case in 2012, they reinforced that. Espinoza 2014, the IB versus Bolivia, the case of compulsory sterilization of a refugee woman. They talked extensively about stereotyping and prejudice. And then most recently, last year, there was an obstetric abuse case and an adolescent sexual abuse case where they addressed how prejudice and stereotyping was a contributing factor in denial of women's equal rights to exercise their equal ability to exercise their rights. So I wanted to remind the court of that rich jurisprudence. And then I asked the court to name the prejudice and the persistent hostile stereotypes of women in the delivery of reproductive health care and in the administration of justice. Then to articulate and condemn the stereotype and its harms, mostly to subgroups of women. And then finally, to develop effective measures of non-repetition. Now let me go through each of these in turn. So naming the gender stereotype. In this case, I identified several gender stereotypes. One is the stereotype of women as lacking capacity to make their own decisions. Somehow when women become pregnant, their rights are suspended. or their capacities are suspended. And there's a distinct stereotype of pregnant women as lacking capacity to make their own decisions. Doctors thinking, oh, we know better. Then there's also the stereotype of treating women as reproductive instruments. And this was brought out in the Colombian Constitutional Court decision of 2006, 2009, I'm forgetting. So treating women as reproductive instruments, and not in terms of their own desires and their own life plans. And then particularly in terms of their access to justice is lacking credibility in their requests. They somehow, many times women's requests are dismissed because they are not perceived to be credible. So these are some of the kinds of stereotypes that I identify in the brief. It's not the only ones, but this process of naming is a very important process. It raises consciousness about how women are treated as reproductive instruments, as lacking capacity to make their own decisions. So by naming them, one raises consciousness about these stereotypes and how there are barriers to women. In addition, there are prejudices, and this was articulated very well by the CEDAW Committee and LC versus Peru, where gender prejudices that prenatal life should prevail over the rights of pregnant persons. As opposed to thinking about identifying the ways to protect prenatal life consistently with women's rights, such as addressing the risk factors for unwanted pregnancy. So there are many ways we can protect prenatal life, but it has to be done consistently with women's rights. Finally, the second point about this brief was to encourage the court to condemn the harms to women and subgroups of women. And here, where my brief overlaps with the brief of Lawyers Without Borders, is in terms of thinking about stigma. The criminal law enables stigma. So we know from the social psychologists that stigma is a dehumanizing process, which is enabled by the criminal law. It's used to mark women, link them to an undesirable characteristic through hostile stereotyping, such as a reproductive instrument, and therefore we can treat them only as a reproductive instrument and not as a human being. The third process in stigma is the process of stigma is to separate them from more worthy women in order to justify degrading treatment through denial of essential health care. Now, overarching all of this, it happens in where there is a power differential. You have the healthcare provider, the doctor, who has power over the woman. And in the case of Beatriz, you had a very recalcitrant judicial system. Finally, the obligation of non-repetition would include such obligations as to educate government officials, judges, doctors, nurses, and to develop gender-affirming policies through guidelines and protocols that we've already discussed. And examples of such protocols are the International Federation of Gynecology and Obstetrics has the ethical committee has a guideline on stereotyping. The Canadian Judicial Council has ethical principles for judges, which specifically states that they cannot, they should not allow interferences of biases, prejudices, and stereotyping in their judge making. So those are some of the ideas to give you a taste of the amicus that I filed in this case. And I only hope that the court will take cognizance of it.
Thank you very much. And thank you for also taking the time to, really go in depth in what your amicus was saying. And I really hope that the court will hear it as well. So I think we're a bit running behind the time just because, well, it's not enough to have 40 minutes but I know that we wanted also to make this webinar very practical. So yes, talk about the case, but also to a bit the fact that you're such an expert here about like some useful tool that you could share to some people who are working here in the field of sexual and reproductive rights that you found useful, some websites, some information if people want to, keep discussion going afterwards, after this webinar. So if you have some, maybe take a little 3 minutes to share them with us. That would be very great. And we can put them in the chat as well.
Okay. Recently, I've been working with CLACI. We have a website of abortion decisions, and CLACI, this wonderful group, has been working on abortion throughout Latin America, has also the Spanish version of that abortion decisions webpage. So essentially, abortions decisions both by constitutional courts and by international treaty bodies are on that website. And CLACI is in the process of having a Spanish version of that. So hopefully that we will soon be able to put up the Inter-American Court decision in the Beatriz case to motivate other advocates to bring similar cases. There's also I edit the ethical and legal section of the International Journal of Gynecology and Obstetrics. And recently, Latin American scholars have published in that section. Isabel Yarmillo from Los Andes Law School in Colombia and Bogota has written a very important article on the 2022 decision of the Colombian court. Now, I mention this decision because the Colombian court, it's the first time that a court is held on women's rights of conscience, women's rights to call their souls their own. And in part, they build upon Justice Bertha Wilson's concurrence in the Morgenthaler decision, where she talks that it's not just a matter of a right to security of the person, it's also a right of the women's liberty, the right of their own conscience to call their souls their own. The Colombian Constitutional Court built on this in their 2022 decision. So I recommend that article of Isabel Yarmillo, which is also on our website under the IJGO articles. There's also very rich scholarship coming out, and there's most recently a book on breaches of confidentiality, which we'll put up on the website, Siglo publishers. Finally, I want to mention the WHO abortion care guideline of last year. The WHO abortion care guideline of 2022 is the high water mark. The low water mark was clearly the Dobbs decision of the US Supreme Court. And the high water mark, these WHO guidelines, it's a very rich guideline. And we here in Canada, I think, need to think about doing an analysis province by province of whether our guidelines, our regulations vis-a-vis access to abortion really meets these guidelines. But they have a very important section on criminalization. And I just want to share that with you. The whole guideline, we're putting the web in the chats, the web address in the chat function. But if you forget it, you just Google the World Health Organization abortion care guidelines and you'll find it. So they talk about decriminalization means removing abortion from all penal and criminal laws, not applying other criminal offenses, murder, manslaughter, to abortion, and ensuring that there is no criminal penalties for having assisted with and providing information about or providing abortion or for all relevant actors. This is incredibly important given cases that are being brought, particularly in the English-speaking Caribbean recently, where a woman was convicted for helping her daughter. Decriminalization would also ensure that anyone who has experienced pregnancy loss does not come under the suspicion of illegal abortion. Finally, decriminalization of abortion does not make women, girls, or other pregnant persons vulnerable to forced or coerced abortion. So those are just some of the tools that are really quite remarkable. And I just want to end, because it is a Francophone audience, with Annie Ernaux's novels, Les Armoires Vides and L'Événement, and how she portrays women seeking and having abortions. It really gives us a real sense of the degradation that women are subject to. Thank you, Julia.
Thank you. Thank you very much. And thank you also for all the tools. And I think they've been shared. And we haven't shared the book, but for the French audience, that's also an interesting one, because that's also the harm, the psychological harm and the physical harm that women can live when they are denied abortion. I think it's something that has been too often taken, like too often diminished. Yeah, I don't know if it's the proper word in English. So I think it's very important also to always put some lights on it and to really insist on it. And I think more and more international, like Special Rapporteur on Torture, but the CEDAW committee as well, some international regional courts have put some emphasis on that. And I think that's very great. We're moving towards something great. You did mention, though, the infamous now Roe versus Wade case in the US. So we've seen some backlashes regarding access to abortion. So yes, in the US, but also, as Karine was saying at the beginning, we have also a colleague who worked on those backlashes in Honduras and Guatemala. In Canada, we often believe that, since abortion is decriminalized, and there's no legal requirement at all, such as parental consent. There's no window, there's no windows to get an abortion. You don't need to have a waiting period. So some people believe, are we okay or should we fear? And also we know that it's right now, abortion is treated as a medically necessary procedure. So it's a part of the Canadian Health Act. But should Canadians also be worried? Should we, what do you think about the state of access to abortion in Canada? Do you think that Canada respects right now its international obligations when it's about access to abortion? And I would say that my last question for you, and then we've been open up to the public. And I want to say, I think the public did not have access to the public chat, but now I think they do. So please do not hesitate to put your question in the chat.
In responding to your question, Julia, I think the price of liberty is eternal vigilance. And maybe it's time in Canada to work province by province to do an analysis to ensure that the way we deliver services complies with the 2022 WHO guidelines. I think I'd start first by working with some remarkable people in the public health sector. I think now of Dr. Wendy Norman, who did it in the University of British Columbia, who did a remarkable job in facilitating access to medication abortion. I think also of Dr. Angel Foster, who's head of the National Abortion Federation Canada, and what she's doing, what these women would know about where the gaps are in service delivery. And I'm sure there are gaps in service delivery. Professor Y.Y. Chen at the University of Ottawa, a common law section, has done very important work on identifying gaps in access to health care for newcomers, not only just women, but all newcomers to Canada. And he has written an article also in the ethical and legal section of the International Journal of Gynecology and Obstetrics, which is on our website, about some of these gaps that newcomers experience. Here, I want to highlight the Toussaint case. I'm sure most of the viewers know about the Toussaint decision of the Human Rights Committee, where Canada was held responsible for denying a woman who didn't have status in Canada, for denying her access to life-saving health care. That case by the Human Rights Committee is now pending in the Canadian courts in terms of whether or not the government will implement it. It's a very significant case, and it will be very interesting to see what the courts do in terms of requiring the implementation of the decision of the Human Rights Committee. Finally, I'll mention that the Canadian ratification of the American Convention is something that is continuing, or the lack of the Canadian ratification of the American Convention is a continuing embarrassment, and I think we need to get onto that.
And I think I like this as an ending for this presentation, for this interview between you and I, because we will now open the floor to some questions. And I think I will give back the mic to Karine, who is going to ask the questions that we have. Thank you very much.
Thank you, Julia. And I will overuse my privilege of asking you a personal question to start with. Because I found it was very interesting that, you know, the study and the link you do between stigma and criminalizing women. One of the arguments that we hear in the region sometimes, and that we heard in Beatriz's case actually, is that, oh, you know, yes, it's criminalized, but we do have exoneration purposes in the criminal code, so they can still use that, right? So I have my personal feeling on that, but I would really like to hear from you, from your perspective. Do you think that is, and how does this kind of argumentation, and what does this kind of you know, orientation that a woman who has been criminalized can always use, you know, different means? How do you think it goes with your, you know, thinking about with the stigma and all this? So I want to hear about you on that.
Well, the indications approach, or the exemptions approach to the criminal prohibition of abortion, creates all kinds of further harms. And they were well documented in the advocacy before the Colombian Constitutional Court in its decision last year. It suggests the exemptions approach, the indication approach, suggests that women have to fit into certain boxes, and they turn themselves into pretzels trying to comply with these exemptions. For example, physical harm. How critical should the physical harm actually be? Do they have to be at death's door? These are all very, very degrading requirements for women to fulfill. And it isn't enabling women to call their souls their own, to make their own life plans, to have autonomy over their bodies, to be treated without discrimination. They're all ways of subordinating women. And so I hope the Inter-American Court in the Beatriz case takes a decriminalization approach and not an indications approach, but time will tell.
Indeed. We have interesting questions also. I will try to translate it because it was a question asked in French. So most of the time, as we said, abortion is considered as a medical procedure. Therefore, the question is, because it's a medical procedure, is a doctor is able to object to practice all type of medical procedure, or is the law imposing him not to do it, for example, if it's criminalized? So how do we deal with this, contradictional, at least at the first sight, of norms?
Very perceptive question. So we've thought until very recently, until the advent essentially of medication abortion, in terms of a medical legal paradigm. And very important work is being done in terms of looking at self-managed abortion and women accessing abortion through the pill. So I think that is a very important frontier where we need novel norms and practices to ensure that women can too have access to self-managed abortion. And here I want to highlight the work of Professor Joanna Erdman at the law faculty of the University of Dalhousie. She is working on this and is working with all those groups in countries, Women Help Women, Women on the Web, all those groups that are trying to facilitate access to self-managed abortion. But it requires a new kind of thinking. It requires us to go beyond the medical legal paradigm and create new ways of thinking about this. So I recommend the work of Professor Erdman in this regard. She's written very insightfully, along with Mariana Prodini in Brazil.
Thank you, Professor Cook. A question now coming from Manitoba. So we have somebody asked that says that, the Francophone populations in Manitoba, the main hospital is a Catholic hospital. And abortion are not allowed in this facility, for example. The abortions are available in other facility, I understand. But our viewers is wondering, whether how do we go with this religious, and then also, around the case law, around the Francophone rights to abortion in that, for example, in that type of situation. So how can we argue in favor of, abortion in a situation like that when the main hospital is actually a Catholic one?
Yes, and it's a tough question which many groups have tried to address. We've tried to address it here in Ontario, but certainly the freedom of religion enables people to hold and practice their religion, but it doesn't enable people to impose their religious views on other people. Michelle Bachelet, when she was Minister of Health in Chile, when there was a fight over emergency contraception, so stated that people have a right to hold and practice their own religion, but they do not have a right to impose it upon other people. Now, when you think about institutional rights, there's no institutional right to conscience. There's only an individual right of conscience. Now, I know there's some exceptions to this. I think Chile is a case in point, but as a general matter, there's only a individual right of conscience, individual right to practice your own religion. Now, some courts are beginning to crowd out that space, and we have to be eternally vigilant to how that's being done. So if you were to challenge the Catholic hospitals in Manitoba, it would take very strategic thinking. Some have carved out in some situations that Catholic hospitals cannot deny abortion where it's necessary to save the life of the individual. They also have a duty of referral. So it's a delicate balance, but something that needs to be addressed. and but very carefully and very sensitively, because everybody does have a right of conscience. Everybody does have a right to hold their religions, but how that's translated into institutional practices can be very problematic.
Thank you. Still in Canada, so as you probably know, this week, the Minister of the Status of Women, Martine Biron, here, she announced her intention to introduce legislation to protect women's rights to abortion to the province of Quebec in Canada. Based on the current state of the law, do you believe that this additional legal protection of abortion rights is needed in Canada more widely? Or do you think we are protected enough with what we have?
Well, I wouldn't want to answer that question in the abstract, and I have full confidence in Quebec women to make that decision. I think any added protection is very, very valuable given the history of how women have been treated. And it would be very interesting, given the previous question on self-managed abortion, whether we're going to go Quebec will go so far as to facilitate access to self-managed abortion under that new framework. So there's still many questions, and it's very impressive that your Minister of Women's Affairs is even considering this.
Thank you. We also want to hear a little more about, you talked about some of the myth and some of that goes around, you know, women's decision and women's capacity to make a decision. Can you tell us a little more about this credibility myth that you were talking sooner? So, example of that in your practice or what you've seen around the world that that is considered by the medical personnel, for example.
Well, I think historically, in the context of medical care, there's been a medical paternalism that doctors know better, and doctors know better in terms of making women's decisions. And there is a lack of respect for women, even when they make decisions that aren't necessarily medically wise. We all make bad decisions in our lives, and people have to be given the ability to make those bad decisions. So there's this lack of credibility, this perception that women lack credibility because they're going to make bad decisions, and therefore medical paternalism is justified. I'm not sure I buy that. So I think it needs to be teased out in different contexts. The prejudice needs to be identified, such as we know better than women, and to name and articulate what that prejudice actually is. Oftentimes in analyzing court decisions, the courts will just say, oh, there's a stereotype here, say lack of credibility, but they don't go deeper. And it's very important to go deeper, to name the actual stereotype, whether it's lack of credibility, whether it's women as reproductive instruments, whether it's women, say in rape cases, you have all kinds of stereotypes. Women were just out playing. So one has to be very careful in naming those stereotypes and analyzing them within the context of what is at stake. You can't divorce it from the context.
Thank you. We have another one. It was initially on Africa, but I will make it broader if if I'm allowed, which is, how do we support women? Like in the case of Beatriz, and you talked about it, Beatriz was a woman from a rural area. She was also poor. We don't know much about education, but we can probably foresee that it was also some type of in the package of, all the stereotypes and the stigma that she suffered. How can we support those women? And how I would go further than that is how is your evaluation of the impact and the differentiated impact on those specific women that has no access to information or very little access to information, and women that has, that, for example, illiterates in the countries, even in countries where it's not illegal or criminalized to access to abortion, but in general, how this impacts differentially women like Beatriz, for example.
So this is a very important question. So looking at the intersectional discriminations and giving space to articulating the wrongs of those intersectional discriminations is really very, very important. The work of Shreya Attry at Oxford she's really phenomenal in what she's done in this area of intersectional discrimination. And the healthcare systems generally think in terms of aggregate numbers. The healthcare systems don't disaggregate, say, for rural women, poor women. And maybe that's a new frontier for the healthcare systems, to think about how the structure of healthcare systems can disproportionately impact upon women. And here's where the work of the CEDAW committee in their general recommendation 24, criminalizing medical procedures that only women need, is a form of discrimination against women. Criminalizing medical procedures that only women need is a form of discrimination against women. Criminalizing medical procedures that only rural women need, or criminalizing medical procedures that only women need, disproportionately impacts on some subgroups of women, such as pregnant women, such as rural women, such as poor women. And in this book that Frontiers of Gender Equality, which has just been published, Professor Charles Nguema, now emeritus at the University of Pretoria from Zimbabwe originally, and I look at a case called the Mapinguri case, where Mrs. Mapinguri was raped and was required to carry the pregnancy to term, even though in Zimbabwe, abortion is available for reasons of rape. She was given the merry-go-round effect, and to prove that she had been raped, the litany. So what we did is we rewrote that decision along this wonderful feminist projects here in Canada, the Canadian Journal of Women in the Law, this project initiated by feminist legal scholars here in Canada, rewriting decisions from the perspective of equality. So we really took a page out of that project, which I think is just so exciting, and it's motivated me in so many ways, to rewrite the Mapinguri decision from the perspective of equality. Many courts do find violations, constitutional courts do find violations of women's rights, but generally they don't ground their decisions in equality jurisprudence. And I think pushing courts to do so, pushing courts to articulate the wrongs of discrimination, as my colleague, Professor Sophia Moreau has done in her book on the wrongs of discrimination, is something that we as advocates can do a far better job of. So that's a long answer to a question which is very rich in its premise.
Thank you so much for your generosity on the question. I know it's a broad question. And I am sorry to say that we have to end up this discussion. This discussion for me could go on and on for hours, but unfortunately we have to stop there. So I really want to thank you, Professor Cook, personally, and from the bottom of the heart of Lawyer Without Borders Canada. You're welcome anytime, webinars like that. Just to thank every people that were present during this webinar, of course. I know my colleague already put in a chat, so if you mind, we will ask you to take a few seconds or minutes to share your experience in the survey. Did you like it? Did you not like it? It also allows us to adjust the webinars. And if you want to support the work that Lawyer Without Borders Canada is being doing, of course, you can always go to our website and you can see all the type of way you can contribute to the work that we've been doing, including donation, including also other forms of it. And just, well, people just stay tuned to other webinars. This is a topic that is very deep in our mandate and what we believe in the organization. So probably will be more about the topics or around the topics. And of course, everybody should keep posted on what's the Inter-American Court's going to be deciding, hopefully in a good way for women's rights. But let's cross fingers. And so thank you everybody. And in that, I will say bye for us now. Thank you so much, Professor Cook, again, and Julia also for your articulation.